international meeting on wine law. This year we have the pleasure to have a meeting and a discussion with our colleagues from Argentina. And I would like to thank Martina Rojo, my dear colleague, for making this possible. So I would like to give her the floor in order to present already the first panel. Martina, thank you very much.
Thank you very much, Theodore. Thank you very much to the Institute and for the organization with this meeting. I am delighted to greet everybody in representation of the School of Law of Universidad del Salvador in Buenos Aires, Argentina, and to welcome everybody to this roundtable update on wine law in France and Argentina. The Faculty of Legal Science of USAL, together with the program Wine and Law of University of Reims, Champagne-Ardenne in France, have cooperated for several years in the research and activities regarding intellectual property and wine law. On this occasion, we are delighted also to organize this activity together with the Faculty of Economic and Legal Science of the Universidad de Aconcagua in Mendoza, Argentina, which is a center of higher studies with great trajectory and recognition in the subject of wine and law. We will be working in 3 panels. The following topics will be discussed. In panel 1, the relationship between trademarks and designation of origin. In panel 2, regulation of wine advertising. And in panel 2, the environmental impacts of the wine industry. So now we will go to panel number 1. In this first panel, we will have the presentation of Professor Theodore Georgopoulos and Professor Azucena Ruth Osorio. Professor Theodore Georgopoulos is professor at the University of Reims, Champagne-Ardenne. He is the Jean Monnet Chair on the European Regulation of the Wine Sector, the only chair in wine accredited by the European Commission. He's the director of the Master in Wine and Beverage Law, chairman of the board of the Institut Chappaz de la Vigne et du Vin in Champagne, president of the International Association of Wine and Wine Law Jurists, director of Jus Vini, the review The Droit du Vin, created in 2018, and of the collection Vin and Droit in the editions Mer and Martin in Paris. We give the floor to Professor Theodore. Thank you.
Thank you very much. Thank you, Martina, for this presentation. I'm very happy, as I said already, to participate to this meeting, and I would like, without spending any more time, to start my presentation on the topic of the relationships between GIs, geographical indications, and trademarks, European and French perspective. Now, in 20 minutes, I cannot deal with all the matters related to the topic. For that reason, I have decided, since we're talking about recent developments, to stick to a couple of recent cases and to see what are the perspectives and the problems that are related to these relations, to this relation between GIs and trademarks. That being said, I have to make a sort of introduction and in some way remind to a certain number of people what are the major elements, the major aspects regarding GIs and trademarks, at least from a European perspective, because this will allow to have, let's say, a better understanding of the questions and the problems that are related to this topic. Now, as an introduction, let me say that when it comes to geographical indications, there is a positive and a negative function of PDO and PGI that are strictly related to the very idea, the very definition of a PDO or a PGI. In fact, when we're talking about the geographical indication, we're talking about the need to meet a certain number of requirements that are set by law. And in this sense, we are having, let's say, the possibility, if the requirements set by law are met, we can have a legal use of the name in question. Whereas in the case of a negative function of a geographical indication, things are, let's say, quite different, because in that case, we are having, let's say, the perspective every time that one single requirement from a European always perspective, one single requirement that is not met when it comes to PDO, PGIs, one single requirement set by the law, or especially the product specification, when it is not met, this means simply that the PDO, PGI, that the product, the wine product, cannot be part of the club of those that can make a legal use of that name. Now, with those elements taken into account, there are a few questions now that must be rather, let's say, explained. The first one, it's the following. Let me remind you that when we're talking about protection of PDO, PGIs at the European level, we're talking about various clauses of protection, a very, let's say, a sui generis system of protection. I believe that the European Union is likely to be the zone of the world where GIs are supposed to be better protected. Sometimes certain say it's maybe too much protection on PDO, PGI, on geographical indications. I'm not someone who believes that, but in any case, it's certain that we have a very complex system of law applying to this matter. Now, what I would like to say is that what I would like to remind at this introductory part of my presentation is that we have protection of geographical indications against the commercial direct or indirect commercial use of the name for comparable products, just like was the case for the cognac from Finland, in a case that was a 2011 decision of the European Court of Justice. We're having also protection against the commercial use of the name by products that do not necessarily, that are not comparable, but they exploit the reputation of a designation of origin. Just like the example of the perfume of champagne that was using that the protected designation of origin in its 1993 decision of the highest civil court of France. We're having also, always in terms of protection against the commercial use of the name, we are having the exploitation of the reputation of the PDO PGI when there is use of the PDO PGI as an ingredient, and provided that the PDO PGI ingredient does not contribute to an essential characteristic of the product, as the European Court of Justice said in its Champagne Sorbet case in 2017. And we're having, and this is what will be quite more interesting, the element I would like to focus on this afternoon, protection against any misuse, imitation, or evocation of the PDO PGI, even if the true origin of the product or service is indicated, any false or misleading indication as to the provenance, the origin, the nature, the essential qualities, or any other practice liable to mislead the consumer as to the true origin of the product. Well, in all those cases, we have various decisions, court decisions, even though there are still a lot of questions to be answered, including, among other, the difference between misuse, imitation, and evocation. But especially with regard to evocation, there are a few questions that have been quite recently developed by the European Court of Justice, while leaving outside still a lot of answers for the future. I would like to discuss now a decision that has been already quite discussed in France and in Europe, the Champanillo case, a recent case, a case of September 7, 2021, which is a case that concerns Champagne as a PDO, and is likely to be one of the cases landmark cases in the field of geographical indications, especially due to the fact that we are having a quite important extension of the protection of PDO, PGI law from a European perspective. Now, before we discuss a little bit the Champanillo case itself, in order to understand the meaning and the importance of the case, I believe it is important to step back and go back to 2016 and see, in contrast, a case which was not quite similar, but still to some extent there are some similarities, that was brought this time not before the European Court of Justice, but before the Spanish Supreme Court. It is a Champagne case. I would say without hesitating that the Champagne case, it is a dark moment for geographical indications in Europe. I think it was a bad moment also for the highest court of Spain. Now, in the Champagne case, I'm sure that many of you are aware of this case. I'll simply like to say a few words, because in the Champanillo case, the European Court of Justice did answer explicitly, by the way, and gave a lesson of law, of European law, European GI law, to the Supreme Court of Spain. Now, here is the case. The Champagne you have here, it is a trademark, but also a sign that is used for this specific non-alcoholic beverage in Spain. It is a fruit juice that it's, as you can see, bebida para fiestas infantiles. It is for kids parties, and it is sparkling, has no alcohol, of course. And you have the bottle, the cork, and the general, let's say, image that may be linked to Champagne. Of course, as such, it is not linked to Champagne, but the fact that where it is using also the word Champagne, that means, which means champagne, is likely to, from a phonetic and visual point of view, it triggers to the consumer's mind the association of thoughts. According at least to the CAVC, that was enough in order to go before courts. The CAVC asked for the annulment of Champagne, asked first to stop Champagne as a trademark, and then to stop using the sign of Champagne in the market. Now, however, the case was brought up to the Supreme Court of Spain, as I said, who in its decision of March 1st, 2021, rejected all the arguments presented by the CAVC, by the Interprofessional Organization for Producers of Champagne wine. If I try to sum up the arguments and the position of the court in its ruling, it says no confusion, no violation. In other words, since the two products are different, one it's an alcoholic beverage, the other it is a non-alcoholic beverage for kids, there is no risk of confusion, which is true. And so with no risk of confusion for the average consumer, this means that the trademark, even if it is similar, and the name, even if it is similar, there is no violation of any first, and no violation of Spanish law, especially provisions on unlawful competition. But even apart from this, the Spanish court said that in any case, even from a European perspective, they didn't see anything wrong with that. This was a challenging decision for the European level of protection of PDO PGIs. I don't need to stress the fact that we are talking about the Supreme Court of a country with an important wine tradition. And actually, according to the Supreme Court of Spain, we are having here a protection that it's limited, in fact, only to the very first of the clauses I have discussed in the introduction of this presentation, meaning that it's only a matter of commercial use for similar products. Outside this, practically, if we follow the Champagne case, the ruling of the court, the reasoning of the court in its reasoning of the court in its ruling for the Champagne case, we find out that probably this is as far as it may go. Now, in the Champagnillo case, however, a couple of months ago, the European Court of Justice, once again, was a CAVC, but now it was at the right address, and probably we need to recognize the courage of the judge of the Court of Barcelona that decided to ignore to some extent the precedent of the Champagne case and to ask directly the European Court of Justice through a preliminary ruling. In the Champagnillo case, you are having this, this sign, which is also which is used for restaurant, for bar serving tapas. Champagnillo, it's the name, and you also have the two glasses of sparkling wine behind. Champagnillo, by the way, meaning small champagne, as translated from Spanish to English. The interesting in this case is that we are having, of course, we're not having the word champagne, just like champagne. It's not exactly the same name. It's not that similar, but still there is a similarity. And by all means, we're having not only a question of similarity of signs, but we also have something important. This time, we're not even talking about different products, but this time we are talking about services. So in this case, the European Court of Justice had to deal with a certain number of questions. And I believe that even though some might say, and I believe that also, that it is a decision that it sticks too much to the tradition and the method of trademark law. PDO and PGIs are protected by using concepts of trademark law. We are losing little by little the sui generis character of PDO, PGI law. Still, at the end of the day, it is a decision that enhances the protection of PDO, PGIs in Europe. So, according to the court, there is no need to go through any national rules, just like the Spanish Supreme Court did in 2016. We don't need to look for unfair competition. It is simply, it is enough to enforce and to interpret and enforce the provisions of the regulation 1308 that do have, of course, direct effect. So no need to prove the existence of any unfair competition practices on the basis of national law. So in this case, the court said that, yes, we can have the protection of PDO, PGIs, even when the trademark is used for services, but not for all kind of services. And I believe that this is a quite realistic approach. They said, let's look for the similarity between the PDO and the trademark from a visual, phonetic, and also conceptual point of view. This is what we already know in the case law of the European Court of Justice and the EUIPO when it comes to similarities when comparing trademarks. Same thing here. It has already been established in the past. But then we also talk about the question of proximity, similarity about services. I don't really like the idea of similarity between champagne and services. It's not a matter of similarity. We cannot compare things that are different and say that they are similar or not, services and products. Rather, it's a matter of proximity. Services that are near, that are in some way related to the product that is protected with a PDO PGI. And it's true that restaurant services have this proximity. So under that circumstances, the European Court of Justice found that Campanillo was evocating, was triggering the association of thoughts in the average consumer's mind. And there is one more question to deal with, which is the question whether this Campanillo case applies only to a PDO with an extraordinary reputation like Champagne. As I often say, geographical indications are all equal, but are there some that are more equal than the others? Rephrasing George Orwell's phrase about equality in Animal Farm. I believe that, and the court actually took the time to explain that we don't really need to look for a reputation that is as extraordinary as in the case of Champagne. We don't need to look at the average consumer at the European scale. It is possible to affirm the existence of an evocation, an association of thoughts at a scale that it's more, let's say, narrow, national or even local. So if a PDO that has a national reputation and not a European reputation is likely to be under attack, under the let's say the threat of an evocation by signs for services or for products that are evoking that in the consumer's mind, in the talking about the average national or local consumer, well, in that case, the Campanillo case, meaning the evocation in case of services, taking into account the proximity between the services and the product under PDO PGI, yes, Campanillo may apply. So we're not in the case of Champagne, but we are likely to have here, let's say, one step forward for PDO PGIs in general. Now, time flies, and I would like simply, before I move to the second case, I would like to compare this Campanillo case with a case that was brought before the EUIPO in the year 2000. It is the case of Porto Marine Hotel. In the Porto Marine Hotel, there was an opposition by the institute in charge of protecting the wines from Douro and Porto versus a business, Alpha Sigma, that has registered, tried to register at the EU level, a trademark for hotel services, which had the name Porto, actually for classes 30, 41, and 43. In this case, and I believe that this is a case that shows the difference, and maybe it shows where we were heading before the Campanillo case. Exactly we have exactly the case where we have the name of a PDO, Porto, which means also port, harbor in a certain number of languages. We have the word Porto itself, but in classes, but for services that lack proximity between the PDO and those specific services. So it is difficult to prove in that case the exploitation of the reputation. Of course, one may say, does this mean that in the case of hotel services, where there is also restaurants and bars, is it by definition impossible to have an evocation? Can we have, instead of Porto Marine Hotel, Champagne Marine Hotel? I believe it depends. I believe we are in these gray zones where, in order to prove the exploitation of the reputation by a trademark, the reputation of a PDO by a trademark, we must really put and assess the risk, not the risk of confusion, but the risk of evocation in its specific context, which is not, by all means, this is not an easy thing to do. So in this case, I believe it was a right decision. The EUIPO said that there was no proven exploitation of the reputation. The second and last case that I would like to discuss, it is the Port Charlotte case. It is, excuse me, the Port 2 Gene case, which is an even more recent case. It is a case of last month. It is a case of October 6, 2021. It is a decision that, to some extent, is distinct from previous case law of the European Court of Justice, or at least shows that we must always be very, very careful when we try to apply previous case law and precedent to more recent cases concerning PDO PGIs. Now, before I talk to the Porto case, Gene case, I would like to remind a little bit a previous case, quite also a landmark case with regard to PDO PGIs, which is the Port Charlotte case. In this 2017 decision, that concerns also Porto, by the way, the European Court of Justice has confirmed the position of the EUIPO and of the Tribunal of the EU, according to which, in order to make sure that there is or not, let's say, either an exploitation of the reputation or even an evocation, we must take into account the difference between the products. In this case, there was Port Charlotte, which was a whiskey, tried to register Port Charlotte as a trademark for geographical, as a trademark for class 33 for this whiskey from Scotland. And of course, there is the word port, which is a PDO for Porto wine. Knowing that port is also the equivalent term found on the product specification of this PDO. Well, in that case, among other, the European Court of Justice confirmed that we must take into account what is known in trademark law, the principle of speciality. Wines and spirits are different products in terms of ingredients, raw materials, in terms of alcohol content, in terms of organoleptic elements. So these are very different. Since they are very different, this is an element that can be taken into account, and the risk of confusion or the risk of evocation is lower. Of course, this is also something that was underlined, stressed in this case, was that the word port has a quite generic character, because it does not only mean Porto wine, equivalent term, but it may also simply mean harbor, and the Port Charlotte is likely to be recognized as such. Now, that was the Port Charlotte case in 2017. Recently, we have here the Port 2 Gene, where in this case, the European Court of Justice, the Tribunal of the European Union, found that there is, in this case, a breach of PDO law. Here, the case is different. First thing is that in this case, that this business is using almost the PDO. As you can see, there is the word Porto, And it's quite interesting that the court did not comment on this, but if you can see, it's Porto, with the exception of one letter that it's almost at the end, and it's written in small characters and in different color. In this case, this means that there is almost Porto that it's used as such. Second, and this is what is even more important, and this is why I believe that this is a quite astonishing case. We are having the fact that the court affirmed that here there is a certain degree of proximity between spirits and port wines, given that they are both alcoholic beverages, that they are targeting the same kind of consumer, that they are consumed on the same occasions, and that they are using the same channels of distribution and of sale. In fact, this part of the decision, of the recent decision, it's exactly the opposite to what the court said in 2017. In the previous case, they focused on the speciality principle, where now they say, since there is a certain degree of proximity, I will take that into account in order to confirm that there is some risk of evocation or an exploitation of the reputation. In fact, here, the court talked about exploitation of the reputation of the PDO because it considered that the word is almost the same. And actually, the court said, without giving even more precision on what criteria it found out that this was the case, but it affirmed that here there was undue advantage taken of the PDO taken by the use of this trademark. So we're having here two decisions, quite recent, one very recent and one of 2017, that one of them is using the principle of speciality to say that there is enough space in order to have trademarks that are quite similar, whereas in the second case, we're having the principle of speciality that is put aside, and they say that wine and spirits, they are both alcoholic beverages belonging to class 33. So which one of these two is now the rule to apply in order to resolve cases of eventual conflict between PDO, PGIs on the one hand and trademarks on the other? I believe that without being said, these two decisions are not necessarily contradictory. Of course, there is exploitation of the reputation. There might be exploitation of the reputation between trademarks for spirits and PDOs for wines, or vice versa. But in order to affirm that, we must contextualize the similarities. In this case, I believe that we must take into account the way that Port 2 is written. We must take into account how all this is presented. You can see that this gin, this bottle, it is to some extent presented as a common bottle for Porto wine. We must take a certain number of elements that are not really taken into account that will allow us to really affirm or not either an exploitation of the reputation and undue advantage taken of the PDO PGI, or a risk of evocation triggered in the consumer's mind. So that was the Port 2 gene, and I would like to finish with something older that, as I said at the beginning, there are some questions that were never given by the European Court, and that they are likely to be asked in the future. I go back to the Champagne Sorbet case, which has been very largely discussed about in 2017, about the use of the ingredients, the taste. But there is something that has not been discussed, which is the question of trademarks. In this case, I remind you that Aldi was using champagne as an ingredient, and it was about using the word champagne on the package. But now here is something else. What about if Aldi was not using that at the beginning on the package, but what if it was asking to use asking to register Champagne Sorbet as a trademark? Of course, one might say, yes, but this would not have a distinctive character because it's a denomination of sale. Yes, but what if it was not Champagne Sorbet as a word sign, as a word trademark, but rather as a complex trademark with figurative elements and with word elements, including Champagne Sorbet? In that case, what would be the answer? Since there wouldn't be any taste, there wouldn't be any product, it would only be the hypothesis of putting on the market tomorrow a product. Will that be that one should have to wait for the product in order to taste it, and then see if the taste is not the taste of champagne, meaning that in that specific case we will have to go and cancel the trademark? Would that mean that the trademark will have to be from the very beginning refused, waiting for the taste? In fact, the problem here in this case, it is that we are having, since the beginning, it was understood that the question of taste, which is a subjective question, to be the criterion in order to understand whether a name, whether the use of the PDO-PGI is allowed or not. This is, of course, problematic as such. Whereas in the case of trademarks, it's becoming even more important. I believe that this is one question to be asked by the facts in the coming years. This is something that has not been explored either by scholars or by, to my knowledge, by institutions, the European Court of Justice, or to some extent the EUIPO. Thank you very much for your patience. Of course, I'll be very glad to answer questions. I just tried to give some hints, some examples of where we are heading. The question of PDO, PGI trademarks, it's getting more and more complex. And I believe that this case shows that we are far from having certainties about the relationship, the complex relationship between PDO and PGI. Martina, thank you very much. The floor is yours.
Thank you very much, Theodore, for this so interesting presentation about these fascinating cases. We already have some questions. We will present them after the presentation of the Argentine part. So now I will present Professor Azucena Osorio. Voy a presentar a la profesora Azucena Osorio. She is a lawyer graduated from Universidad de la Aconcagua, the co-host of this meeting. She has postgraduate studies in wine law and economics in Universidad Nacional de Cuyo in Argentina. She is professor of law in the subject wine legislation and wine law at the School of Economic and Juridical Science in Universidad de la Aconcagua, Mendoza, Argentina. And she is a member of the Association of Wine and Wine Law. Professor Osorio will be presenting in Spanish and will be sharing the translation in English of her presentation regarding PGI PDO in Argentina. Now this is the presentation. It's okay?
Bueno.
We are seeing the presentation. Very good.
Buenos días. En primer lugar, quiero agradecer la participación en este encuentro en nombre de la Facultad de Ciencias Jurídicas y Económicas de la Universidad de la Aconcagua y en el mío propio. Comenzaré dando un panorama diferente al que ha tratado mi antecesor, porque mi visión va a ser desde el punto de vista de las normas aplicables en nuestro país. En primer
Professor Osorio
término,
will be presenting the laws of Argentina. That will be her approach. So now we will continue with the translation. Please. Puedes continuar, Azucena.
Perfecto. Muchas gracias, Martina. Bueno, en primer término tengo que decir que en nuestro país a través de la ley 14878, se creó el Instituto Nacional de Vitivinicultura, que es un organismo público con autonomía funcional, técnica y financiera, que depende del Poder Ejecutivo a través de la órbita del Ministerio de Economía. Este organismo es un organismo administrativo que tiene la función de control y fiscalización de los vinos y de las bebidas espirituosas. Este control comienza desde la plantación de los viñedos, porque exige la inscripción ante dicho organismo, luego en la elaboración del vino, en el fraccionamiento, circulación y expendio del mismo, realizando tareas de fiscalización y control sobre la genuinidad del producto vínico, teniendo la facultad a su vez de sancionar en caso de cometer infracciones. Es importante destacar que la ley 14878 indica como bien jurídicamente protegido la salud pública y no la industria vitivinícola. Además de las funciones que he mencionado, el Instituto Nacional de Vitivinicultura, a través de la ley 25.123, tiene competencia en cuanto al reconocimiento de las indicaciones geográficas y denominaciones de origen controlada. Para ello, dicha ley establece el trámite al cual deben someterse los particulares y también es el propio instituto quien puede llevar adelante este reconocimiento, debido a que es de oficio. Una vez concluido dicho trámite, se debe notificar al instituto de la propiedad intelectual a los efectos de la registración del mismo. El otro tema que voy a abordar es en el sentido de la actualización que ha realizado la Organización Internacional de la Viña y el Vino, comúnmente denominada o conocida, mejor dicho, como OIB. Y antes de adentrarme a abordar este tema, es necesario destacar la participación especial que ha tenido este organismo internacional en la definición, en la promoción y la protección de las denominaciones de origen y las indicaciones geográficas. Es más, ha hecho hincapié en que los estados partes realicen la protección en forma interna y haciendo valer en forma externa o internacional de acuerdo a los pactos celebrados. La OIB en la resolución del 2021 ha establecido o ha rescatado este concepto de denominación de origen controlada y de indicación geográfica, indicando que es objeto de propiedad intelectual. Por lo tanto, está protegido por las leyes internacionales y sobre todo en materia de deslealtad en la competencia. Dicho esto, me adentro en el tema en cuanto a la nueva significación que le ha dado al concepto la OIB respecto del nuevo concepto de las indicaciones geográficas y denominaciones de origen controlada, que tiene que ver con la denominación que se reconoce en el país de origen por la autoridad competente y que tiene de un lugar determinado y cuyas características o cualidades, y en este punto es donde se renueva el concepto, porque hace hincapié en la reputación, que tiene que ver con las bebidas, o el vino y las bebidas espirituosas, en relación con el lugar de origen. ¿Qué es lo relevante de este concepto? Que al colocar en el concepto la reputación, hace referencia a lo que es el medio ambiente, que es tan importante para todos en este momento. Entonces, el concepto antes dado por esta organización fue receptado por la mayoría de los países que integran la organización de la OIB, en las legislaciones propias de cada país. haciendo enfoque fundamentalmente en el recurso natural, como es el suelo, el agua, el clima, la amplitud térmica y también el recurso humano. En nuestro país, especialmente la 25123, adopta este principio de los recursos humanos solo para las denominaciones de origen controlada. Antes de seguir avanzando, quiero rescatar que nuestro país tiene, además de la ley 25.123, cuenta con otras, como por ejemplo la 25.380, que nos habla de las indicaciones geográficas y denominaciones de origen controlado respecto de los productos alimenticios y a su vez se complementa con las leyes, con la 25.123 y se complementa con las leyes de marcas, con la ley de marcas colectivas, con la ley de competencia leal. Y en el marco del Mercosur existe el reglamento de vitivinícola del Mercosur. Este reglamento tiene la función de establecer las condiciones con las cuales cada uno de los estados partes tienen que cumplir para que los productos vitivinícolas puedan circular dentro de este mercado. Pero deja a salvo que las leyes de cada uno de los países siguen vigentes en este marco, ¿no? Por lo tanto, dice también que este reglamento sirve como unificación de las legislaciones de cada uno de los estados partes y las condiciones que deben cumplir para poder circular dentro del Mercosur. Y a su vez establece que los productos que ingresen al Mercosur deben ajustarse a este reglamento. Ahora, lo interesante es que, si bien existe este reglamento, los únicos estados partes que han ratificado al mismo es Uruguay y Paraguay. Sin embargo, la Argentina, que ha participado en la realización de este convenio, no ha sido ratificado aún. La nueva resolución, este reglamento ha sufrido varias actualizaciones a lo largo del tiempo, y la última del 2021 hace hincapié en la defensa de la identidad del producto agrícola. Esto nos da el punto de vista de no perder la identidad propia de cada uno de los estados en la elaboración de los productos. Tiene que ver indudablemente con las indicaciones geográficas y las denominaciones de origen controladas, que hacen referencia al tema del lugar de la producción del producto vitivinícola. En el mismo marco es importante señalar que la Argentina, dentro del Mercosur, es el país que mayor exportación realiza, considerando el 20% de la producción, que comprende como el 2.2% a nivel mundial de la exportación, luego de la Unión Europea, Estados Unidos, Chile, Nueva Zelanda, entre otros. Pero también es importante señalar que en el consumo interno se abastece con la elaboración mayoritariamente propia de nuestro país. En este punto podríamos decir o mencionar que Chile no forma parte del Mercosur, por eso se lo incluye dentro de los demás países que realizan mayor exportación en materia vitivinícola. Y volviendo al tema del nuevo concepto dado por la OIB, y que a su vez ha dado recomendaciones a que los países integrantes lo adopten, porque asimismo para la protección del medio ambiente, nos podemos identificar a las indicaciones geográficas como aquellos que ubican una determinada zona a un producto que se elabora en un territorio que puede ser provincial, regional, y cuyas características de ese producto tienen que ver con las cualidades y condiciones con las que se realizan, y fundamentalmente ahora se pone el foco en cuanto a la reputación que tienen en la elaboración, teniendo en cuenta el medio ambiente. ¿Por qué digo esto? Porque el factor humano y el factor natural ya estaba señalado en el anterior concepto. Sin embargo, ahora engloba también al medio ambiente. Y esto nos sirve también para poner unión a la tierra y al producto. Y también, como consecuencia de ello, garantizar una producción sustentable. Y cuando se habla de sustentabilidad, como condición inescindible, tenemos que hablar de la protección del medio ambiente, es decir, de la huella de carbono y la huella hídrica. ¿Qué se quiere significar con esto? Que se debe lograr el menor impacto posible en los nuevos emprendimientos, tomando como de línea base cero antes de la realización de cualquiera de estos emprendimientos vitivinícolas. Con esto también va a repercutir en el producto en sí mismo, pero también en la comercialización y en el valor que tendrá ese producto, teniendo en cuenta en miras que realmente en los momentos en que vivimos tiene mucho que ver el tema medioambiental que se tiene como foco para cualquier actividad que uno va a desarrollar. Luego, en nuestro país es importante destacar que por ser la resolución 2021 muy reciente, obviamente la disposición reglamentaria no ha sido modificada, pero es interesante que el Instituto Nacional de Vitivinicultura, como organismo de aplicación, digo puede porque obviamente no es obligatorio, pero al ser la Argentina miembro de esta organización, podrá tomar este concepto y valorarlo al momento de otorgar o reconocer nuevas indicaciones geográficas. Y respecto de la denominación de origen, hago la salvedad que en nuestro país existen solo dos y se ubican aquí en la provincia de Mendoza. Entiendo que si se solicitaran nuevos reconocimientos, también deberían cumplir con estas pautas que ya mencioné. En este punto es interesante señalar que nuestra legislación también hace una distinción, que ya lo mencioné, pero es importante recalcar, que en cuanto a las indicaciones geográficas pueden solicitarles los particulares en cualquiera de la cadena de la industria vitivinícola. Y también lo puede hacer de oficio el Instituto Nacional de Vitivinicultura, pero no así en respecto de las denominaciones de origen controlada, justamente por el factor de recurso humano que se tiene en cuenta. Luego analizaremos cómo se combina en las marcas comerciales y las indicaciones geográficas o denominaciones de origen controladas, si tienen en sí similitudes o son diferentes, y en su caso, si el uso de las mismas es obligatorio. Bueno, debo decir en primer lugar que las marcas comerciales y las denominaciones de origen controlada y las indicaciones geográficas permiten informar a los consumidores de las características o cualidades que cuentan el producto para una mejor elección. Ahora, respecto de las indicaciones geográficas y denominaciones de origen controlada, hacen referencia al lugar, a la zona geográfica del producto. Y esto, por ser así, la titularidad es colectiva o indeterminada, es decir, que puede ser utilizado por cualquiera que esté en la zona y que cumpla los requisitos. Mientras que en las marcas comerciales asignan o designan o ponen en relevancia a un producto determinado que compite con otros en el mercado y cuya titularidad solo puede ser utilizada por el titular de la marca. Respecto de su uso en la indicación geográfica y la denominación de origen controlada, sabemos que pone en valor, obviamente, al producto que puede, que figura en la etiqueta la indicación geográfica, porque precisamente son vinos de calidad y apuntan a establecer un mejor conocimiento de la zona donde se ha desarrollado. Pero eso no significa que sea obligatorio, así la ley lo determina, pero a mayor abundancia, el Instituto Nacional de Vitivinicultura también, por resolución dictada, ha establecido que el uso es voluntario porque es en el interés del particular establecerlo o no en el etiquetado. Y respecto de las denominaciones de origen controlada, pasaría exactamente lo mismo. Ahora, el uso de estas marcas y de la denominación de origen controlada y de las indicaciones geográficas, para poder utilizarlas, primero tenemos que registrarlas. Como principio general, así lo establece la ley, para que queden protegidas tanto en el ámbito del territorio nacional como a nivel internacional. Es allí donde el Instituto Nacional de Vitivinicultura, dado que es un trámite que puede demorar, porque pueden ocurrir diferentes factores, entre ellas oposiciones, que hacen que demoren el trámite de esta inscripción registral, lo que implica que a veces no se puede utilizar para productos que se pretenden exportar. Por ello, el Instituto Nacional de Vitivinicultura y conjuntamente con el Instituto de Propiedad Intelectual han sacado la resolución que pueden ser usadas estas indicaciones geográficas o denominaciones de origen antes de su inscripción, teniendo ¿sí? la protección legal como si ya se hubiera culminado el trámite. En el caso de productos que sirvieran para que pretendieran exportarse, sí deben ajustarse a las normas de este país. Bueno, muchas gracias. Quedo abierta a las preguntas que quieran formular.
Muchas gracias, profesora Osorio. Thank you very much, Professor Osorio. We already have some comments in the chat, so we can pass to the comments if although you are in agreement of this. First, we have a comment regarding the case that Professor Georgopoulos was talking about in the position of the Spanish court. Jennifer says that if you meant that the position of the Spanish court goes for the acceptation of the use of the PDO if there is no proximity between the service and the PDO, regarding the Campanillo case.
If I understand the question well, in the Spanish Supreme Court, it was a matter of conflict between a sign, a trademark, and a sign regarding products that are not similar to the products for which the PDO are protected, wines. So it was the case about PDO product and product that is not a dissimilar product. In the case of Campanillo, on the contrary, it was the case of services, PDO wines versus services. So I believe that if we, of course, these are two different questions, but if we try to see and compare the reasoning of each one of these two cases, we must say that in the case of the Spanish Supreme Court, they simply said that since we have products that are not similar, there is no way, there is no problem of confusion for the consumer, and so there is no problem of violation of EU law on PDO PGIs. So I believe that a fortiori, in the case that if the question was the Champanillo case, if it was brought before the Spanish Supreme Court, the answer would be, well, this is even more, even further. This is even, the distance is even bigger, because in this case, we don't even have products versus products. We're having products versus services. So I'm pretty sure, and this is what the court said when it mentioned it explicitly, the European Court of Justice in the Champanillo case last September, mentioned the Champin case of the Spanish Supreme Court in order to say that this is a decision that is not in compliance with what the ECJ has already said these last years on the protection of PDO PGI. So yes, I believe that in the case, if we compare the Champanillo case to the previous case law of the Spanish Supreme Court as established in the Champin case, we are in totally different positions. In the case of the Champin case, we have a protection that it's a minimal protection, only the very first part of the first clause, only for the same kind of products. Here, we have some that it's goes even beyond products that are not similar. We're having here something very, very different. Services, provide, of course, that these services are to some way related to, there is some kind of proximity between the PDO products that are protected and that is protected, and of course, the services in question.
Thank you very much, Theodore, for the answer. Okay. Again, Jennifer says thank you, of course. Thank you very much also to Jennifer. Now we have a question regarding the Argentine legislation. Tenemos una pregunta para la profesora Osorio del doctor Ricardo Gordo-Llobel. We have a question from Ricardo Gordo-Llobel, who some of you may remember, he visited the university a few years ago with another project. So Professor Gordo-Llobel would like to know this point that Professor Osorio was making between the registering of the trademark and this authorization that Azucena was talking about. What happens between the registration of the trademark and the GPA. Azucena, entonces, si quisieras ampliar este concepto que dijiste sobre esta relación de las marcas durante el trámite, ¿no? de su aprobación.
Sí, creo entender la pregunta, que hace referencia al hecho de que si el Instituto Nacional de Vitivinicultura requiere que sea la inscripción de la marca anterior. Y en realidad es al revés, cuando estamos hablando exclusivamente de indicaciones geográficas y denominaciones de origen controlada, porque la autoridad competente para el reconocimiento de estas precisamente es el mismo organismo. Una vez concluido el trámite que está establecido en la ley, con todos los requisitos que se deben cumplir, es recién cuando se notifica al Instituto de Propiedad Intelectual a los efectos de la registración de la misma, y de allí comienza a tener la protección legal para poder utilizar estas indicaciones geográficas.
Perdón, muy bien, muchas gracias. No sé si Ricardo se resolvió la pregunta. So it was fine, Ricardo, the answer of Azucena. Thank you. I will have also another comment for Theodore, if we have time.
Mira, Martina, quiero agregarle algo a la pregunta porque me parece también
una aclaración para Ricardo. Sí.
Sí, me parece interesante establecer que sí, que en el orden interno se exige la registración de la marca, y como dije, también puede ser utilizado previo la registración conforme a las resoluciones estas dictadas por los órganos administrativos, pero que a nivel internacional obviamente quedan sujetos para el resguardo legal al país donde se decide exportar.
Yes, it's very important what Professor Azucena just told us, because we know that not all the countries are part, for example, of the Accord of Madrid. So that would be also a point, ¿no? Por ejemplo, el tema si somos o no parte del Acuerdo de Madrid, etcétera, ¿no? Excelente, muy bien. Gracias entonces de Ricardo. And if we have the time, I have one question for Theodore. We have the time, Theodore, you think?
We are running a little bit behind schedule.
Okay,
so...
okay, so we can do it at the end. Perfect,
okay.
very good. Yeah, okay. Excellent.
So
thank you very much for the first panel.
Thank you very much.
And we continue for the second panel.
Could I please ask you, Martina, to present the panel and also the two speakers? Thank you.
So in this second panel, we will talking about the regulation of wine advertising. In this panel, I will be presenting the Argentinian vision of the subject, and the European vision will be presented by Mr. Stefan Martin. Mr. Stefan Martin is a member of the Court of Appeals of the EUIPO, a member of the Community Plan Variety Office, and a former attorney of law. He is also an adjunct professor at the Universities of Aix and Strasbourg in France. And I will be then presenting the Argentinian vision of regarding the advertising of wines, in representing the School of Law of Universidad del Salvador, and in my specialty of Professor of International Economic Law and the relationship with industrial property. So my presentation, I will start, if that's okay, and then I will be giving the floor to my colleague. Okay, now, it's okay. No, it's not okay. It's okay. So, well, I will go directly to the presentation just because of the time. I would like to share some ideas regarding the regulation of advertising of wine in Argentina. First of all, I would like to share some comments regarding the general rules of consumer protection in Argentina. In Argentina, there are specific rules to protect consumers, both at the national and the provincial level, because we have in our country a federal system of government. So at the national level, of course, we have the major provisions of the Constitution. In Argentina, the consumer protection is part of the constitutional law. This is very important to highlight when we talk about these kind of things, because we have an article in the National Constitution, Article 42, which states the right of the protection to the consumers. So we are talking not only private law, but also public law. And this is a different approach that we have in Latin America when we talk about consumer protection. So it's in the Constitution itself where we will find in our country the need to protect consumers regarding their health, their safety, their economic interests, the right of truthful information, the freedom of choice, also the education for the consumption, and this is also related to the defense of competition. So this is a point that I would like to make at the beginning, because when we talk about these issues in Latin America, especially in Argentina, we have to bear in mind that we are talking about constitutional level protections, not only private law protections. The authority in charge of the control of the consumer protection in Argentina will be at the federal level, but also at the provincial level. And the authorities will have the power to make investigation, take preventive action, and also impose penalties in case of violations. Talking about marketing practices before going specific to advertising, I would like to share that regarding marketing practices and advertising, there are also regulations that forbid advertisements which are false, misleading, abusive, discriminatory, or inducing the consumer to behave in a harmful manner. So there are regulations required to the requirements of information, but also there is regulation which regards to the practices themselves. We have then the relation with this constitutional protection with specific laws, specific acts, which apply the National Protection of the Consumer Act and also the regulation of commercial loyalty, which is provided in a decree, the Decree 274 of 2019. This decree talks specifically about advertising. The decree regulates the aspect related to advertising and also to the organization of contests or raffles for the marketing of products. So we have these requirements, and relating to the wine industry, we will have during the recent times some cases which we found violations of these regulations. For example, some years ago, we found a case by one very big winery, the winery Bodega y Viñedos Santa Ana. Santa Ana Winery have organized a contest, a game, which was going to be made in Mar del Plata. Mar del Plata is the big holiday city of our country. So this winery has organized a contest which was called El Juego de la Costa, who was going to be held in the city of Mar del Plata during the summer season, of course, and where for the purchase, it was required to purchase products to be able to participate in the contest. So when the consumers bought the products, they were given prizes and gifts via a roulette, a very traditional type of game, but which was considered illegal because in our country it's not allowed to have this kind of games or contests with the compulsory purchase of the means for the participation. So we have, in this case, a fine imposed to the winery because it has elected a practice of promotion which violated the requirements of the Loyal Commercial Decree to do not make the condition of the purchase for the participation in the game or raffle. Also, we have some recent developments in Argentina regarding labels. We have this year, 2021, the passing of a new regulation for the labels of products, which not only apply to wine, to beverage, of course, it also applies to other kind of products, but who also are presenting some defies to the industry because of the new requirements for the label. But for the advertisement specifically of alcoholic beverage, in Argentina, we have a law. We have a law, which is the law 24,788. But this a law regarding to social health. We can see in the name itself of the act is titled Fight Against Alcoholism. So we see that it is a law of public health. This is a law regarding to the control of the consumption of alcoholism. And that is the main specific regulation where we find the limits to the advertisement of alcoholic beverage, including wine. So of course, the limits are the age that the advertisement should be directed to people over the age of 18 years old, which is majority of age in our country. It will be forbidden the advertisement which uses the images of people under 18 drinking, so that will also consider illegal, and also will be considered illegal the advertisement that suggests that the consumption of alcoholic beverage improves the physical or intellectual performance of the consumers. And also, it will be forbidden the advertisement that implies that the consumption of alcoholic beverage is a stimulant to the performance of violence or sexual manifestations. So this will be the general limits for the alcoholic beverage, and in the wine industry, we will have to comply with these general rules because we don't have specific rules for wines. One of the things that we should say also is there is a very big role in this topic about the soft law, you know, the codes of conduct. The codes of conduct have came in our country to cover some gaps found in the legislation. So we have a very active role of the industry representatives, for example, about la Argentine Chamber of producers of wines or spirits. They have their own codes of conduct, which of course are soft law, but are very well observed and respected because they are of course part of the behavior of the members of the industry itself. So we have general rules in hard law and we have specific rules in soft law. So that is the reality, but also makes us think about the need of more specific legislation about these topics. One of the things that are, we say, really enforced is the placement of the warnings in the products and in the advertising. These warnings, for example, drink in moderation, or prohibited the sale to minors under 18 years old, are these we call mandatory legends. So we say text of warning, which should be included in all kinds of advertising and also in other ways of promoting the consumption of alcoholic beverage. They should be used in graphic, in press, but also in any kind of advertising in the television, in the radio, in the cinema. And also, there are some very specific limits to the size of these legends, if they are in a written form, or about the time where you should listen to them as consumers if they are presented in the radio or in the television. So these mandatory legends or these warners are compulsory and they should be, of course, applied to penalties in the case of infringements. But for the penalties, we will find all different kinds of amounts to the fines. We don't have a very clear pattern for the amounts of the fines, of the punishments, because our legislation says that for the application and grading of penalties, they should be considered the infringement itself, but also the market position of the company, the amount of the benefit obtained, the degree of intentionality, the seriousness of the risk of social damage arising from the infringement, and other circumstances. So we will find sometimes very low fines, sometimes higher fines. One specific example that we can share occurred some years ago regarding a winery called Bodegas del Fin del Mundo. It's a very well-known winery. This winery published an advertisement which was published in the written press, in a magazine, and the advertising promoted the service of a restaurant who served the wines of this winery, and which included a phrase, in Spanish of course, which say, "Enjoy the wonderful universe of living wine at the end of the world experience." Bodegas del Fin del Mundo means wineries of the end of the world. So there was this advertisement in place, and the authority applied a fine because the advertisement did not include such mandatory legends. The advertisement did not include the warning, which is required to any kind of advertisement of alcoholic beverage. So there was applied a fine because it was not clearly presented. This advertisement, drink in moderation, prohibited the sale to minors under the age of 18 years old. The winery, Bodegas del Fin del Mundo, appealed the decision in the justice, and this case arrived to the Chamber of Appeals, the Superior Tribunal in this case, which actually ratified the sanction, saying that this was a case where we were talking about a service. They were talking about a service of a restaurant where the wine was sold, and the winery was co-responsible for this advertising, and also it was co-responsible for the respect of the legal warnings in the case related to alcoholic beverages. So we will see then that the wine industry was also considered responsible for an advertisement which was about services, not only about the product itself of the wine. The most recent big situation, discussion about the publicity or advertisement of wines took place at the public level between the wine industry and the government of Buenos Aires City. You know, Buenos Aires City is the capital of Argentina, it's the biggest center, and also has a lot of population, a big amount of population in the place. Buenos Aires City, which is an autonomous city, is like a province, it has the same level as a province according to our federal system. Buenos Aires City has passed a law which has, in 2017, Buenos Aires City forbade all kind of alcoholic beverage advertising in the public way, in the roads or in the streets. This was a very strong law passed by the local authority of the Buenos Aires City, and that caused a big political and media discussion, I would say, because that was a battle between the wine sector and the government of the city of Buenos Aires. Because in the banning of this advertising of alcoholic beverage, it was included also the banning of the advertising of wine. And that was considered very badly by the industry, because in our country, the wine was recognized as a national drink, bebida nacional, by another federal law. So the wine sector accused the legislation of Buenos Aires City as unconstitutional, because it was forbidding the advertisement of a product, the wine, which is protected by the consideration of national beverage, national drink. So there were different discussions, both there were lobbying at the public sector, at the private sector there were also pressures. There was a lot of also discussions at the media about this problem. And finally, there were settled some negotiations, and Buenos Aires City accepted to exempt from the prohibition of the advertisement in the public roads and the streets to the wines, based on the idea that the wine are the national drink of Argentina. So nowadays, it is possible to advertise wine in the public ways of our big capital city. So with these little reflections, I wanted to present the idea that in Argentina, everything related to advertisement relates to commercial loyalty, but also relates to consumer protection. And it's a very important aspect of our legislation, because it has constitutional level. We are talking about rights protected by the Constitution. So they're very strongly protected. And there's a different paradigm from other parts of the world. But I will say as a conclusion that I think that Argentina owes itself a more accurate, a more modern legislation in the field of advertising, because nowadays we have also different discussions regarding the sponsorship, regarding the role of influencers in the advertisement, and they are not very clearly regulated still in our area. So we need regulations that acknowledge these new developments in advertisement and also considers the different roles of the industry in the small companies and the biggest companies. Thank you very much.
Thank you very much, Martina, for your presentation. Now, I would like also to ask my dear friend Stefan Martin to present the European aspects of wine advertisement within the next 30 minutes. Stefan, the floor is yours. Thank you very much. Stefan, we can't hear you. I don't know if you're already talking or not, but your micro is off.
Hola.
That's much better. Thank you.
Sí, muchísimas gracias por invitarme a este evento. Intentaré describir en pocas palabras la ley francesa sobre la publicidad de bebidas alcohólicas. Es realmente un placer. Muchísimas gracias a Theodore también. Vamos a cambiar el idioma. I will present the situation from a perspective from the French law, with a few hints deriving from European law. I have to say that from a French perspective, it's a kind of an odd subject. One has to recall that until the 60s and beginning of the 70s, it was kind of normal that you would be feeding a child with putting some wine in at the early age of a couple of months. And also it changed a little bit in the 60s, where in the what is called the carnet de salud of the family, the government would be indicating that wine consumption is not so good for children. It's also not before 1976 that in the French law of personal liability, the fact to be drunk was an excuse when you had a car accident, and was not an aggravating factor. So in this type of country, out of a sudden, to try to bring the consumption down and to have a law on advertising was kind of odd. One has also to keep in mind that at the beginning of the 20th century, the consumption of wine for male workers was around 7 liters per day. It seems that it's extravagant, but that was the situation. Now, nowadays, we are at 40 liters per year. That gives you a fair picture of what has happened. What also happened in the 80s, that out of sudden we discovered that alcohol consumption was not so good for the public health, but also not for the individual public, for their own health. So in the 90s, we finally adopted a law towards the advertising of tobacco and for wine. In a nutshell, the advertising for tobacco was totally banned, and advertising for wine was kept to a certain minimum, as we will be discovering in the next 20 minutes. The legislation has been attacked on certain human rights issues, especially because the right of property is protected by Article 17 of the Charter of Fundamental Rights of the European Union. In the second paragraph of Article 17, it's said that intellectual property shall be protected. So here we have a law that it's actually limiting the use of trademarks, and trademarks are property. So Unfortunately, or fortunately, depending on which side we are sitting, the courts have confirmed very quickly that the legislation was conform because it was balancing the right of property, and on the other side was balancing public health issues, and the public issues were more important than property rights. So this, you can see it on various decisions that I've cited in my presentation. I will not go into the details. What I can tell you is that the conformity with the French law with EU law was confirmed on 2 occasions by the Court of Justice in 2001 and 2004. So that closes the issue of the legality of the law which is called the Law Ouvinha, from the name of the health minister who promoted the law in the 80s and the 90s. I will now change to the second part of my presentation, identifying recent trends in advertising. So we have emails that are sent. So you can imagine what the situation, the following situation, where you have a company that is located outside of France and is sending emails to French consumer, promoting wine or promoting alcohol, or generally speaking, promoting alcohol beverage. What do you do with that type of situation? We have more and more websites for alcohol brands that are also located in countries where the legislation is as not strict as the French law. And what are we doing with this type of situation? A third trend that we can see is a lot of advertising going on mobile phone, computer screensaver, where you have an alcohol brand name or logo. Again, it's the issue. And we have social media and influencers. I invite you to have a look to these 2 pictures that I'm showing in my presentation. Here you have this blonde lady. She's actually enjoying wine, but you can clearly identify the brand of the wine if you zoom a little bit on that. So that is an influencer, and you know what they are doing. They are trying to promote products. They're getting paid for that, sometimes in nature, so they will receive some wine, or in real money. Here we have a second lady. She's also enjoying it, and you have in both cases that you can see these influences. They might be located within the territory of France. What are we going to do with that? And that will be part of my presentation. Very quickly, the legislative framework we have at EU level, a directive from 2010. Well, that's basically, so the directive, for the people that are not so familiar with EU law, you have the regulation, they have direct effect in the member states, whereas directive has to be implemented by the national legislation of each member state. So here we have a directive, and that provides that advertising for alcoholic beverages shall not be aimed specifically at minors. So that means that typically at an hour where children would be at home and until they have to go to bed in these hours, the advertising will be prohibited. I will go to another article of that directive, but it's the teleshopping of alcohol beverages is allowed under certain circumstances. I will leave you with that because that's not so important nowadays, but you have the text of the law and you can have a look to it. So on EU level, it's one of the basic idea of the directive is to promote self-regulation instead of having intervention from the courts. So that is reflected here in Article 9.2 of the directive, where member states and the Commission shall encourage media service provider to develop codes of conduct regarding inappropriate audiovisual commercial. And we'll come to that later on when we're going to speak about self-regulation. But that is really part of the overall scheme within the European Union, is to promote self-regulation in terms of, for example, code of conduct of advertising agents. Let's now move to France. We have here the Basic Law of 1991. It has been amended on a few occasions to reflect changes, but also to reflect the lobbying of the alcohol beverage producer that were actually complaining that the law was too strict and that in their competition within the European Union, in other countries, the beverage manufacturer were allowed to do more, and so on and so forth. I don't want to, I have no intention to go through all the different laws, but just to say that in 2005, the law was actually amended to oblige mandatory warning for women that are pregnant, that it's not really a good idea to drink while you are pregnant. In 2009, the law was again amended to reflect the internet. And in 2017, the law was again amended to reflect certain concerns for territory that are outside of Europe. I mean, these departments of Guadeloupe, Guyana, Martinique, La Réunion, where they have other concerns with wine, and they have made the law there more restrictive in these. Very quickly, the scope of the law applies to drinks over 1.2 volume of alcohol, so therefore most of alcohol beverage will fall within the scope of the law. Next, what constitutes advertising? So I have here to make a special mention for those who have an interest. This legislation will be defined in the Code de la Santé Publique, which in English translates for Code of Public Health. So you will not find that in a law, you will find it now in the code that regulates all the public health. So what is interesting here compared to other legislation is that the law uses two words, advertising, but also uses the word propaganda. Propaganda in French is a word that has a very specific meaning. Propaganda is a propaganda of ideas, propaganda is a propaganda of political. And so by using the two words, it's the legislator in 1991 wanted to show that we are talking of more than advertising, and we'll see the impact of the word propaganda on the interpretation of the law. Next stage, advertising, and you will see that the court have broadly defined what constitutes advertising. So, for example, a blog could be constituted advertising, even if it's a blog where you promote wine tasting, when you promote discovering certain principle of wine tasting or enology, but that will fall within the scope of the law. The Cour de Cassation, which is the Supreme Court of France, however, put an end to this never-ending expansion of the definition of advertising in 2017. It was the factual background was a show that where people would be having a dinner, and that show with a showmaster. And in the course of the dinner, they will exchange, they will talk about their own life, the life of their friends, etc. And as French people are, they would start smoking during these dinners. And the association that is actually fighting fighting all terms of habits, addictive habits, they brought a lawsuit that eventually went to the Supreme Court, and here the Supreme Court put an end and said that, look, that it's not advertising, it's just a bunch of people that have not get the sense of you own propaganda against smoking, they're just smoking, and they are French. So therefore, in this situation, the court said there are certain limits. So there is also an exception that has been introduced in 2016, is now reflected in the code itself, where an other article has been added, does not constitute advertising, in far that content, images, depiction, description, commentary, reference to a region of production. So that means that if you have a documentary talking about region of production, name of a place, a geographical indication. Here we are talking about a protected geographical indication, for example, Bordeaux, Champagne, etc. A terroir, so the name of a terroir is a link between a region and a product. An itinerary, a place of production, know-how, historical, cultural, gastronomic heritage linked to an alcohol beverage. This was meant to prevent that basically you could not show on French television any documentary talking about French region, because you know, as a French arm, they talk about food, they talk about wine, they talk about spirits, and if you prevent them in a documentary to talk about that, then you don't have any documentary that you could display on television anymore. So that was the idea of the introduction of this exception. Then you have what is called the content restriction. So very quickly, what is allowed, not much, alcohol content, origin, name, product, etc., etc., but not much. That is allowed in terms of content. You are also allowed to put the name of the terroir, the awards received by the product, the geographical indication, color, taste and smell, and packaging. This is it. Everything that goes beyond that will be contrary to the law. So, also, the law, there is a specific provision that prevents the use of any positive, evocative images and or text associating alcohol with pleasure, glamour, success, sports, sex, opinion leader, etc. And here you have the basics of advertising, because advertising tries every time to play on pleasure. So if showing a person that seems to enjoy his glass of wine, or showing a person that has a lot of money because it's on with a very exclusive car, a sportsman, or alluding to the fact that will enhance your sexual performance, that will make you more attractive, all that is forbidden under French law. Here, a decision, a very recent decision from against the Supreme Court, where the beer manufacturer Kronenbourg, one of the biggest brewer in France, they had a website and they used in two movies. They used the Legion of the Phoenix, Territory of the Legion, and so these were characters. And the court said no, because these characters do not fall within what is allowed. Allowed is, you know, the name of the producer, etc., etc., and that is forbidden. And therefore, we will actually exercise control over that. And they were sanctioned, they were condemned by the court and sentenced to, because it was again something that had been introduced by this association for the fight against addiction. So now let's very quickly have a look to the means of communication that are allowed. So this you will find in this specific article, and let's go to TV. So initially on TV, any alcohol advertising was totally banned. And now in 2016, again, the law has been amended to allow marketing with a certification of quality and origin linked to a production region or cultural, gastronomic, or regional heritage. So here that it's not advertising itself, it's in the course of something that is broadcasted if it satisfies these criteria, so linked to a production region, culture, gastronomic, or regional heritage, it will be allowed. So next, radio. Here we have a time limitation. So from 12 p.m., 5 p.m., you can read it, and that it's, and again, you have the same limitation as for television. Now, newspaper. For publication for minors, so below 18, it's totally, obviously, totally prohibited. And you can have product information in the newspaper, according to what I just said before. Now let's see commercial signs that you could find on the road, that you could find in the city, where you would have different signs. And again, here you have a limitation. And for example, here the court said that this advertisement for this whiskey, William Lawson, and picturing a good-looking guy, even we cannot see his face, but very muscular. It highlights the virility of the Scottish pub, and it's not one of the information contemplated by the act that I described above, and therefore the manufacturer and the brewer of this whiskey, they were condemned. Now we have also a specific regulation of the signs that you will find on a truck, on the delivery truck. Here you can just have the product designation and the name and address of the manufacturer. This is it. So for example, here, as you can see, you have Heineken with the product itself, but you could not put, for example, tonight is Heineken night, for example. No, you can just put what is meant here. Traditional festivals, if they are dedicated to local alcohol beverages, I've taken here, it's a picture of the beer fest in Munich that is going on in September and October. But these are the type of traditional festivals dedicated to alcoholic beverages. So that means, for example, you have a beer fest, but the fair must be built around the beer and not the beer an accessory to the fest. So for example, you must have a fair trade for cognac, for example, and not cognac to be drank while they are doing the fair. Universities, etc., wine tasting organization, that's a very specific exception for them, not so important. Then in movie theaters, you have a total ban initially, and then it changed also for what I've just said, the cultural, gastronomic, regional heritage. Then we have these signs that are placed outside. Again, there has been something in 2016 that allows certain, in the same vein. I give you here an example of Jameson, and here you can see that sign has been allowed because it's linked to the quality and origin of the product. Just that. You can see Jameson l'Irlandais, so meaning that it's the reflection on the origin, the geographical origin of the product. However, this poster has been sanctioned by the Supreme Court in 2008 because, as you can see here, you just don't have just a product. You have different aspects that highlight the attractiveness of nightclubs. And so here, that is the difference between Jameson here, which is kind of an objective, and here where the advertisement of this Absolute Vodka highlights a certain aspects of the nightlife that would incite people to. We are going now to sport. What you see here, the Heineken shirt is totally prohibited in France. You cannot have, so for example, the national team could not have something with alcohol on it. That is totally, and the same thing applies to the sign that you will see here in the stadium. And now turning on the packaging itself, you have here, for example, the court said that packaging can constitute an advertisement in itself. Here you have 4 football player, and that endorsement is totally prohibited, as I said, even if it's just on the packaging. So here you can see that it's an endorsement of the Premier League, the football league in England, and that it's not allowed in France. We have here promotional, you know, these things that are given for free by the manufacturer, and that is allowed when you just have the name of the manufacturer, and when it's a direct sale to the consumer or visit of the production site. So you cannot have this promotion activity turned into to consumer without a sale. Very quickly, point of sale marketing, and here you have a maximum for alcohol. So let's imagine you have a tasting that is organized in a wine shop. This sign, the size is limited to not even a square meter. So now turning to social media, it was not specifically addressed before 2009, and now it is addressed. It is permitted by law under the same restriction that I said. I mean, the content remains the same, that is allowed. Here we had a decision in 2013 where the court said that the advertising is not private, because even if it's on Facebook, on a wall of someone, but also it is unsolicited and systematic. So meaning that and that it's also a limit that it's imposed by the law. So you cannot send something that is totally unsolicited to person without infringing the law. Lastly, patronage, so that it's the situation where you have a company that it's actually endorsing for a good cause, let's say for a restoration of a chateau or something in a forest, or so you have that patronage. Here, the patronage is limited for documents that in writing and documents circulated in the course of an event, for example, in a catalog, that would be allowed. We don't have much of case law on that. I will now go very quickly, and that will be my last chapter of my presentation, is indirect advertising. So what is indirect advertising? That is this famous concept. I'm not allowed to advertise cigarettes. I will allow shirts. I will advertise on shirts, for example, the Marlboro shirt that you can see here on. The law says that as soon as it recalls an alcohol beverages, the prohibition is the same. You cannot use indirectly what you cannot use directly. So there is a small exception that has no importance, because it was a grandfather clause for products that were already on the market before 1990. I will give you two illustrations for indirect advertising. One was a publication in a sport magazine of an ad where you could see Michael Schumacher, and he was in front of the billboard, and behind the billboard you had Mark Foster's beer and Mum Champagne. So obviously that is direct advertising, because you cannot, on the basis of a reportage of a race, do what you could not do directly. And you have here the direct reference to the rationale of that decision of the Supreme Court. Same thing here at a music festival, you had an endorsement that is for the next slide, that is for a cigarette company, but that it's the same thing for alcohol. It was a music festival, and so here I want to tell you one thing with this indirect advertising. It's the issue of trademark coexistence. So let's assume that you have a trademark registered for alcohol beverages, and then you have a second trademark owned by someone else, and it's registered, the same trademark is registered for shirts. So here we have really an issue, because the owner of the second trademark, despite that fact he has no link with the first company, the beverage company, could be prevented of using it on the basis of the restriction. What the legislator wanted to avoid is that just the beverage company, they will set up a new company, nothing to do, at arm's length, and just for the sake of doing Marlboro shirts, for example, or whiskey shirts. That is what it wanted to be prevented. What has happened, that is the case law, the vast majority of the case law has rendered a decision where in that case, we would just cancel the trademark related to alcohol beverages. So that is the case law that has been adopted by the courts. I have given here you the list. It's kind of really a strange case law. It's very pragmatic, but it raises a concern, especially with Article 7 of the Paris Convention, which says that the nature of the goods to which a trademark is to apply shall in no case be an obstacle to the registration of the trademark. Therefore, I think that all the case law developed in France in terms of this strange issue of trademark coexistence, when you have a trademark that is for wine, and then you have a trademark that is for, let's say, other product, falls within this article. Lastly, we have obligation of health warning, like in every country, that it's something which is not typically French. My last, and I will take 10 seconds, what has happened, and I'm talking here about the erosion of the Loire. Yes, there has been an erosion. The legislation that was initially adopted was very strict and would have prevented practically any advertisement on alcoholic beverages. Within the next 30 years, there has been an amendment adopted, but also the case law has gone in a certain direction. And that allows now maybe a more flexible approach towards advertising. If you consider what people are now saying, you have always a division. You have a division between the one that would totally prevent alcohol, punto, and then you have a division towards the one who would be inclined to come back to the situation before the 90s. I think somewhere in the middle, as usual, there is certainly the solution. And I believe that after all these years, we have found, at least I believe in France, a common ground that at one point discourages certain attitudes at one point. So for example, if we compare ourselves with what is going on in Germany or what is going on in England or in the United States, you know, with this drink binging and this overall consumption that we see, I think in France we do better. We do better because I believe not only because of the law, but also because of the education towards alcohol. And I think that is what is missing in the law, is that any parent should encourage their children to have, if they want, a reasonable consumption according to their own tastes. Thank you very much.
Merci beaucoup. Thank you very much, Stefan, for this very interesting presentation. Could I ask you to stop sharing your screen so that we can?
Yes, I will.
Thank you. Thank you very much for this and a very interesting presentation. Martina, how do you want us to proceed? Are you going to take questions?
Yes, just I will answer the question there, and we pass to the third panel. So if somebody has another comment, we will do it at the end. It's okay. So just have a question which is very
short.
Very short. Just if the Argentinian law is covering the sales of wine via e-commerce or social media. Yes, the Argentinian legislation covers all kinds of sale, including the e-commerce, but what is not so well defined is the role of these not professional people doing advertising, which are the influencers, as Stefan was also talking about in the European case. Thank you very much for the question.
Thank you. Thank you both for this for the interesting presentations. And I see Leila.
Leila is there. Okay.
Who is already here. So I let you present
great.
the third session, Martina.
Of course, excellent, with perfect timing. So we will start now with the third panel. In the third panel, we'll be talking about the environmental impact of the wine industry. And the first panelist will be Professor Leila Devia. She is professor at our university and other universities. She is also public director of the Regional Training and Technology Transfer Center of the Basel Convention. She's also an expert reviewer of the United Nations in climate change. So our dear friend Leila, you have the floor.
Thank you, Martina. Thank you, Christoph. Thank you for the invitation of participation to this important event. So I would like to present something about some reflection about environmental impact on wine industry. As you know, sustainability is very important in all the chain of the industry, but in the case of the wine production is one of the most important agricultural activities around the world. The production of wine involves the use of large number of environmental resources such as water, fertilizers, and other organic products. Moreover, it produces a large amount of wastewater and organic waste. So it's for this it's important to treat this kind of waste. So there are a possibility to have a sustainable production in the wine sector. And in the case of Argentina, and in the case of our region, is a guide that I would like to present, a guide of best practices in this sector. As I say, the sector has the problem to use many of the reserves of water and generate many wastes. And this is also not for only the environment, the impact of the environment, of course, is the impact of the production. So to share, to protect the production also, you have to follow this guideline. The guideline that I present is a guideline that then I send a link. It's in Spanish, but it's a guideline that did by INTI, National Institute of Industrial Technology, the National Institute of Vitiviniculture, and also INTA, National Institute of Agriculture, and the government of Mendoza, and also the Ministry of Environment and Sustainable Development. So this is some approach, no? Quality and safety. The vitiviniculture industry has to protect the quality of the wine and the quality of the chain, of the value chain, and the safety in the production. When I hear some cases, I remember a case of the wine that is adulterate, and is adulterate with something about wastes. So it's many years ago, but there are many cases in our Supreme Court about environmental and many contamination provided from industry, and one is the industry of the wine. So the other thing that is important, and the European Union knows very well, is the sustainability and life cycle. As I say, the industry has to try to have some rules, to follow some rules for the exportation for the European Union, and the sustainability and the analysis of the life cycle is very important. As also life cycle approach, as also the footprint. It's very important, the footprint in all of the change of the sustainable viticulture industry. So there are a definition in the guideline of sustainable viticulture. There are action focused on sustainable wine production, because there are two or more than two cycles: the cycle of production and the cycle of commercialization of the wine, and also the role of the consumers, because the consumers are also very important in this chain, in this life cycle. So the guideline also talk about viticulture, of course, about the process. How is the process? How is the areas that the wine is produced? The agro ecosystem management, how to use the soil, how to use the environmental impact assessment to produce wine, soil management, how to manage the soil, and how to also use the fertilizers. This is an important, also there is an important, many important cases about fertilizers and agrochemicals that use in the industry, and this is a problem in this moment, but the industry need the agriculture, the agrochemical fertilizer, but some fertilizer there are prohibited in the convention that, for example, the Rotterdam Convention, the Stockholm Convention on POPs. There are many of these that the industry cannot use because it's prohibited. Irrigation management. One of the also other problem is the use of the water. So in the case that our country, there are two or three provinces, more than 2 or 3 provinces, that is a federal system that has many industry of wine. And in the case of Mendoza, and in the case of Salta and San Juan, but in the case of Mendoza, Mendoza has not water, but it used the water very well, because it was one of the provinces in Argentina that had his first in 1995, the first law of irrigation. So it's something contradictory because he has not, it's not a territory with water, but he used the water, and there is many cases and many conflict with the province of La Pampa and the province also of San Juan because for the use of the water. Phytosanitary management, as I say, how to manage the fertilizers, how is the fertilizers that you can use, how the fertilizers that is effective and is not prohibited. So it's many things that in this guide and in this type of orientation for the industry is very important. Wine quality is also other item, and also the quality of the water in the cellar, in the viñedo, I don't know how to say in English, and also the solid waste reduction and management. There are not only hazardous waste, there are solid waste, and there are many technologies that you can reuse this solid waste. So there are technical assistance for this reuse in the industry of wine. Effluent management and its reuse, this is also important. Also important is all that the workers that have to in the material handling and in the security. Also air quality. There are some cases of fumigation and some cases of also some cross-contamination that affected air quality. One of the important things also seeing the Glasgow meeting last week is the efficiency in energy consumption. This is for all the industry, but this industry uses a lot of energy, and in the case of the Latin American countries, it's very important this type of industry. So what happened with the reduction of the consumption in energy? And I have this guideline try to manage the process to become sustainable, but also to become competitive. So this is a subject, no? And we talk about something about the certification. Sustainable shopping also, because in Argentina and also surely in the other countries, we have also shops with the wineries and with the industry. And so one item that is a part of this is the packaging of wine. How to reduce the packaging in the case of the industry of wine. So there are many of our industries, corporate social responsibility actions, and adequate configuration of the plant of winery. This is something that the guideline provides, but it's important to try to see. There are environmental impacts of the industry, environmental impacts of the producers, environmental impacts of on the consumers, environmental impacts on the chain of producers. So for this, we have another thing that is the certification. As you have a certification for organic wine, you have also certifications for sustainable production and change and of course chain of the wine quality. So I think that is an important subject, not only for this guideline, and there are some regulations, very news about it. But I think that the waste generated by the wine industry is a special waste. It's not because each industry has the type of waste. So I think that is a cost, another cost for the industry, but it's very important, above all, face-to-face, the exportation and the quality of the wine. So I think that is not so new, but it's a challenge to the industry to improvement choices of environmental and sustainable wine industry. So thank you very much. I left my email if you want to have the guideline, the entire guideline. I think that it's in Spanish only, but I think that there is an abstract also in English or French. I think in English, and I left to share. Okay, and I think that we send the guideline, and I send also the regulation of some provinces, but now it's very important this type of approach to the industry. And the consumer, the play of the consumer is very important also for environmental impacts. And our industry is very important in type of wine, Malbec, and the others in Argentina. And it's for this we have to try to produce with better practices from the environment and from also the competitiveness. Thank you very much.
Thank you very much, Leila. Gracias, Leila. Here I also put in the chat my email, so if any of the assistants would like some other materials, some other things from the 3 Argentine presenters, will be, of course, very honored to answer. So now I will present Professor Raquel Ouvinha de Oliveira. She is the director of the Chappaz Institute of Viners and Wine at the University of Reims, Champagne-Ardenne. Since September this year, she has a background in oenology from the French institution, and also she holds a doctorate from the Paris Sud University in France in chemistry, and a master's degree from the State University of Rio de Janeiro, Brazil. She was responsible for the research and development area of the Franken-Pommery Business Group. So, Professor Ouvinha de Oliveira, you have the floor.
Thank you very much, Martina, for the presentation. Thank you for the opportunity of presenting today. I'm going to share my presentation. Okay. I don't think it's working. I think I'm not allowed to share. Yes, it's. Can you see it?
Absolutely, thank you.
Yes,
thank you,
can you
Raquel.
see it on full screen?
Yes,
It's good?
Yes, of course.
Okay, thank you. So I'm going to present a winemaker's point of view of the environmental impact of the wine industry and the strategies to a sustainable development Champagne. As Dr. Leila just presented, there's a lot of points of environmental impact during the production, the process of production, wine production. So I'm going to show you some examples that we have in Champagne. So a quick review of the Champagne appellation. We have 0.5% of the world vineyards area, 9% by volume of global consumption of the sparkling wines, and 33% by volume. We have a stock over 1 billion bottles of champagne, so a very tasty on the ground, let's say. We have 6,200 growers, 130 cooperatives, 360 champagne houses, a very big business. Champagne is a region that is committed to the sustainable development. As Dr. Leila said, the footprint is very important. We have, over the last 15 years, we had a decrease of 20% of our carbon print per bottle. And we have the aim, the objective to decrease it by 75% in 2050. In the last 15 years, we had also less 50% of phytosanitary products and nitrogen fertilizers. And we hope to have 0 herbicides by 2025. So this is very close. We are really running after this objective. So we hope to get it. We have till now 20% of the area of the appellation with us environmental certification, and we hope to have 100% of it by 2030. It's also very optimistic, so we hope to have it. Till now, we have 90% of the industrial waste treated and recycled, and 100% of wine production effluent and byproducts treated and recycled, which is a very good number. The good things of Champagne that the growers are committed, and they are all together working in the same objective to get better and to leave a better place to our children. Champagne was the pioneering region to lead the mating disruption to combat an insect, that's leaf furler moth. I'm going to speak a little bit about it in the next slide. We have the largest fleet of electric starter tractors in the region, and it was the first region to access the carbon footprint, it started in 2002. So Champagne is an AOC with a worldwide reputation and is committed to continue this environmental friendly production. In the early 21 years ago, we identified 4 key areas for action. So the management of water research, reduction of inputs, preservation of landscapes, which is very important and sometimes we forget about it, and the energy and climate challenge, a big challenge for our humanity. Champagne is committed, but the implementation of these changes takes time, and we all know about it. So how to produce quality wines and champagne when reducing the use of inputs? This is, sometimes we just think, okay, we have a product and it's impossible to replace it. And so it's a very hard work and it takes time and a lot of research. Today, we can replace herbicides and insecticides by using mechanical or manual operation. It's less worry for human and environment, but it's very time consuming. And we need to invest a lot in equipment. One of the most common vineyard treats, as I said before, is this insect that's called Lobesia botrana. It attacks the vine in different ways and different stages of the plant's growth cycle. Here we use something that's called sexual confusion. It's a very efficient method that allows us to no longer apply insecticides. And it's a very small, it's 4 centimeters inside, like the picture I just showed in your right side. We install this small dispenser through the vineyards, and the combination of this pheromone female go through the air and get male confused, trying to locate the non-existent female and to presenting them from mating. And this is, I cannot use it alone in my vineyards. I need that my neighbor use as well, and the one beside and the one in front. It's a very collective way of working, and it works very well till now. So let's talk about climate challenge. And this is probably the biggest challenge facing as our humanity, and we are very important actors in this way of work. As part of the European Green Deal, it was in September 2020, is to raise the greenhouse gas emission target, including emission removals, to at least 55% compared to the last decades. So this is about all Europe and all the industries. Let's talk about fresh air, clean water, buildings, how to make buildings cleaner and greener, healthy and affordable food, more public transport, cleaner energies, longer last products. So like it was said before, it's shopping habits. So let's get better. Future-proof jobs and skills. So in this change, we need new skills as well. We need that the students and the new professions have new skills, and more important than the skills and the new point of view, a new mentality, a greener mentality, in order to work in this way. And which strategies Champagne has till now? As I said before, carbon footprint assessment, we could decrease in 20% the dioxide of carbon per bottle. And by reducing bottle weight, waste recycling and biomass conversion as among the most significant initiatives to get this less 20%. And we work also in the vine and wine to encourage people to implement sustainable wine growing methods, transport and travel, to put forward cleaner transport, buildings, improve buildings energy and efficiency, responsible procurement of goods and services, so opt for low environmental footprint goods and services, or let's buy it from someone inside our country. Let's get a better mentality of consumption, and active involvement. So I'm going to make it, but I need all my colleagues to make it too. So lighter bottles, we reduce by 7% the weight of each bottle. So it has a big impact of the reduction, and reducing 8,000 tons of dioxide of carbon per year. And another way to face this climate challenge is working on our grape varieties. Today in Champagne, we have mostly Pinot Noir, Meunier, Chardonnay, with a little bit of Pinot Blanc, Petit Meslier, and Pinot Gris. Today we have Enha Restur program, that is a sustainable resistance program that they work with innovative plant breeding program set up by the French National Institute of Agricultural Research, And what they are looking for in this, with these new varieties, good sensory qualities, of course, because we need to drink champagne and our champagne with the same taste. Effective and sustainable resistance, so resistance to diseases, and good growing capability of the vine. So this is the three main things that they are working on with these new grapes. 4 of the first series of varieties planted some years ago resulted in 4 new being included in the catalog. We have 4 new included in the catalog. They are called, you have the picture, Arbatin, Floreal, Vidocq, and Voltis. For example, Voltis has a small and compact grapes with medium-sized berries, and their organoleptic qualities are compatible with the identity of Champagne wines. It means a lot of freshness, but not very aromatic. Everything we need to mature this wine on lees, because we need freshness good acidity to keep it on our cellars during many years before to sell it. And another way another study that I'm making, it's the wider spaced vines. It's VSL, vignes semi-large in French. That the spaces between rows are from something like 2 meters, and the traditional way is 1.5 meters. So this is very new, and people can plant like this a little bit of their vineyards from now as I study. And the density is between 4,000 and 5.5 thousand vines per hectare. And the traditional way is 8,000 vines per hectare. So everything is going to change because we need to tailor it. The growing techniques need to be all adapted to this new method. So mechanical machines need to be changed, and maybe we are going to pick up the grapes in another way in the future using machines. So let's see how it's going to evolve this method. So these studies are ongoing, but so far we have a slightly less susceptible grapes to spring frost, like Voltis. The grassy stripes are easier to maintain with mechanization, because today, if we use the grassy stripes, it's very difficult to maintain with our machines that we have now. And we have improved resistance to water shortage, even if water shortage is not a big problem now in Champagne, but with the change of the temperature, the change of climate, it can be a problem very soon. And the acidity could be better maintained in the grapes. The evaluation is on the way to determine the consequence of such a change, because it's not only about the visual vineyards, and it's always about the grape and the quality of the final product. So the agronomic, the enological, the environmental, economic impact, and the landscape itself, because all the pictures today of the Champagne, we have the very narrow vines planted, and then it's going to completely change. So it's a very new thing, and let's see what we're going to have in the next years. Also, we have the strategy in the production. So during the harvest, we need to change our practice. We have already 1.8 degrees of warmer in our temperature, medium temperature. And the aim of those practices is to change now and to be used with this change for the future. So which strategies we can use during harvest? The aim of all of this is to avoid the grapes to get hot. And during the harvest, we can harvest this in the early morning, as they used to make already in the south of France. We avoid grapes to be exposed directly to sunlight. We use light color harvest beans, because the Comité Champagne, they made a research that they compared white beans, red beans, and blue beans, and the white beans were lighter, and not lighter, sorry, it was less warm, and so they say it's better to use light beans during the harvest. And the grapes need to be pressed quickly, otherwise the warm grapes, and it's not a good combination for bacteria, for all the microbiological problems. And the fermentation, during fermentation, is clear the musts, and to have strict hygiene rules and keep must above 20 degrees. And the early addition of yeast. This is a good thing to do. And which strategies regarding the grape must composition? When temperature increase, ripeness increases too. This is very important to keep it in mind. So sugar concentration increase, acidity decrease. It's the opposite that we want in champagne. We want the good acidity. We need it for this product, and the sensitivity to oxygen increase, so we can have oxidation problems. So all these changes need to adapt our practice and also in the grape must composition in order to have a good product to taste at the end of the process. So this is a winemaker's work and not a lawyer's work, but we need you, of course, for all the legislative things and problems. Thank you, gracias.
Thank you very much. For my part, Raquel, thank you for your presentation. I will only ask you to stop sharing your screen so that we can move back and have all the persons. Thank you. Over to you, Martina, maybe if there are any questions or in order to close the session. I'll just since I don't want to have a lot of back and forth, I would just like to, for my part, thank everyone for the very interesting presentations from both sides of the Atlantic. And by all means, this is a first meeting that we're having between our universities and our countries, but I'll be very happy to continue working on various aspects of wine law. This is for my part. Martina, the floor is yours for questions, comments, and for closing remarks. Thank you.
Thank you very much, Theodore. Thank you for the comments in the chat. We have different greetings. So it was a very, very important first meeting, as Theodore was saying. We found a lot of points in common between the legislation, and also we found the fees, the challenges, as in the last part, the panelists were talking also. So for me, just to thank everybody, to thank the different organizations, also to thank the program for the technical part, the assistance of the organization, and the three law schools involved, Universidad de Aconcagua, Universidad de El Salvador, and the University of Reims Champagne. Thank you very much, everybody, and have a nice fin de journée. Thanks.
Thank you.
Thank you. Take care. Bye.
Muchas gracias. Un saludo para todos.
Hasta luego a todos. Un placer.